Hi, this is Jim at Trek World, and we have the response from Heritage Auctions submitted to the LA court system as a result of their lawsuit. Now, a lot has happened since the last time you and I have spoke. There are quite a few things that I'm going to go over in this video, and I also want to give you a heads up. At some point later in this video, I'm going to tell you about the subject of the next video, and it's going to solve a 6-decade-long mystery. So this document that was filed with the court the other day is referred to as the defendant's answer to complaint, an answer document. And it breaks down their response in several different areas. First and foremost, a general denial. The defendant, Heritage Auctioneers and Galleries, Inc., and Brian Tennis generally and specifically deny all allegations of this complaint. This is a standard boilerplate answer. It'll be on the first paragraph of anybody who does an answer back to a lawsuit. It is basically your statement saying, I didn't do this. The next part of the document goes into the individual points that they believe illustrate to the court why they are not responsible for the damages done in the initial complaint. Now, the first one of these affirmative defenses is failure to state a claim, arguing the complaint does not state a cause of action upon which relief can be granted. A core underlying principle in Heritage responses is that they do not view the allegations of fiduciary damage as valid. They're saying that you're suing me and you're asking damages, but you can't show how I hurt you in any way. Obviously, this is one for the courts and lawyers to fight out, so I'm not going to go pretty deep into that, but I just thought I'd bring that out. Is that, Heritage's standpoint is all what you just said doesn't really apply. The next point they bring out is something called consent, claiming the plaintiffs consented to the actions in question. Now, this one gets a little bit tricky. They actually lay out that there's like 3 pieces of paperwork that existed over a period of time that Dustin and Jason had access to. And those individual pieces of paperwork defined the engagement between Jason and Dustin and Rod Roddenberry and how to get the model to Rod's hands in exchange for a finder's fee. Key to their position in this document is their claim that the plaintiffs signed the first 2 pieces and refused to sign the third, that you stopped midway through. And in doing so, they're basically saying that's not fair. You consented to everything, but when it came down time to sign things, you disagreed. Next point, agreement to arbitration. Asserting the claims are subject to arbitration per the consignment agreement. In other words, you signed an agreement that said you would not sue me under any circumstance. And if you did have a complaint, you would bring it to arbitration. So Heritage is saying the plaintiffs jumped the gun on that one. To be honest, they did not. As we saw in the claim last month, there was correspondence at which point the lawyer from the plaintiffs specifically identified 4 different arbitration agencies in the state of Texas that would be agreeable for them. And Heritage did not respond to that. So Heritage is saying, hey, you agreed to go to arbitration. And the plaintiffs are going, yeah, and we've suggested arbitration, and you didn't want to use it. Again, it's up for the judge. Those are the 2 stances. The next thing they point out is punitive damages barred, contending that the plaintiffs have not stated facts sufficient to warrant punitive damages. Okay, punitive damages, to me, in my head, they're punishment. This is how you get your big money in a lot of these lawsuits, because you can actually prove that other than just the dollar value of the item, you have sustained some other kind of damage that needs to be compensated. This could be damage to your reputation or other things like that. This particular point ties to the first point in their answer, where they're saying, hey, there's no cause, and therefore, if there's no cause, there's definitely no punitive damages. And the next point they bring up on this same topic is causation of damages, arguing that any damages were caused by the plaintiffs or other third parties. Next up, comparative fault, claiming the plaintiff's actions contributed to their damages, if they exist. You made your bed, now lie in it, is what we were told when we were kids. Waiver estoppel, asserting the plaintiffs waived their claims or are stopped from asserting them. I can tell you I have not used the word estoppel in many years, and I did not bother to look it up to see its proper pronunciation on the internet. So forgive me if I misstate, but the description is correct. Then they mention Failure to mitigate, arguing the plaintiffs failed to mitigate their own damages. Next up is another word that I'm not familiar with, LACHES, I'm assuming it's pronounced lox, which claims that the plaintiff's delay in asserting their claim bars them from actually pursuing it. Although in this case, I'm not 100% sure exactly how that plays in because the document that was pending signature was from mid-March and lawsuit was brought in May. But there may be other circumstances that I'm not aware of because, as we've said before, these are all allegations, and up until now, we've only heard the plaintiffs. This is the first time we've heard the defendants. The next point they bring up is something called unclean hands, asserting that the plaintiffs acted unethically. I think that pretty much speaks for itself. Then they bring up impossibility, arguing that it is impossible for the defendants to perform their obligations due to plaintiffs' actions. So here is something they actually talk a little bit about, okay? And that is, you entered into an agreement with us to transfer ownership to Roddenberry Enterprises in exchange for a finder's fee. But you didn't sign the document that was necessary for us to be able to get the money for you or to give the model to Roddenberry Enterprises. So you've left us in a state right now where we have a product and we can't do either piece until this gets resolved. Now, this is important because this is Heritage Auctions acknowledging for the first time that they have possession of the model. And I'll highlight that area right in here that shows you they're saying they can't actually deliver the model. So our belief that Roddenberry had it, not true. And then the last thing they bring up is reservation of additional defenses. Just sort of like discovering Aladdin's lamp and then going, wish number 1, give me $1 million. Wish number 2, give me a big house. Wish number 3, give me more wishes. And basically it allows them to continue to add additional defenses as they think of them throughout the trial. Then we move into an area of the response document called the prayer for judgment. And in this, the defendants request the plaintiffs take nothing by way of their complaint, that judgment be entered in favor of the defendants, and the defendants should be reimbursed for all legal and court costs. Again, this is boilerplate. This is the whole point of filing this answer document, is to simply say, I didn't do it, and you need to pay my legal bills. Now, Heritage, though, wasn't done completely. They also filed a cross-complaint against Dustin, and we're going to take a brief look at that cross-complaint document right now. The cross-complaint by Heritage Auctioneers and Galleries, Inc. against Dustin and Jason outlines the background of the dispute. I want to give you an update on the model's history itself. Watch this channel, subscribe, like, set notifications, because very shortly in the near future, I want to put a video up and I'm going to be able to lay out the entire timeline from the time it disappeared, who had it, where it went to the time that it was sold in auction. I think you will be fascinated by the story, including the consignment agreement and the subsequent issues with the title to the Starship model. The reasons that they feel allow them to cross-complain are as follows. Breach of contract, alleging the plaintiffs breached the settlement agreement by refusing to sign the transfer agreement, that third document I spoke about a moment ago. Second point, breach of warranty, claiming that Riach breached the consignment agreement by not having good title to the model. We're going to talk about that, okay? Part of the response from Heritage includes the words, and we'll bring them up here on the screen in a moment for you, that after they had the model, they became aware of the fact that Roddenberry Enterprises had a more significant claim to ownership than the plaintiffs did. And arbitrarily, on their own, they chose to recognize the Roddenberry claim of ownership rather than let that be decided by a court or even by Dustin and Jason, okay? They actually go through that and they go, hey, we found out about this. We believe it's accurate. So we reached out to Rod and we talked about the fact that, hey, we can do this, and in doing so, their comments back to Dustin and Jason actually included the words, hey, if you don't do this, to avoid a long lawsuit and a lot of attorney bills, you need to go ahead and sign this thing over. So not only do they recognize the ownership of Roddenberry on that model, but they also then recognized the supposed action that Roddenberry would take if he didn't get the model back, and that it would cost Dustin and Jason a lot of money and tie up money for years. Finally, they bring up misrepresentation, accusing Dustin of misrepresenting his title to the model. So this is tied right into what we just spoke of, but this also runs completely in the face of the video I did last week or so for you, which explains to you how legally the title of that model did belong to Dustin and Jason. Everything about the lawsuit has nothing to do with that title. That title belongs to Dustin and Jason under California law. Okay, now let's return back to the cross-complaint. We have just heard their causes for action. Now we get to hear their prayer for relief. Heritage requests damages in excess of $100,000, attorney fees, and costs of suit. So basically what they're saying is we stand to make $100,000 as a result of this finder's fee. So we're owed that. We're owed whatever damages the judge decides are due to us in excess of that, plus our attorney's fees and any other costs associated with the suit. This actually brings us to the end of these two documents for now. There may be other documents that are filed, and when they are filed, I will review them with you. But key points in this whole situation right now were the initial plaintiff's allegations. The plaintiffs alleged that Heritage and Chains acted unethically and fraudulently handling the sale of the Starship model, resulting in financial losses. There's a video on that. The defendant's denial. This is what we just went over. The defendant's denial all allegations and assert multiple affirmative defenses, including consent and arbitration agreements. And then finally, the cross-complaint. Heritage counters with claims of breach of contract, breach of warranty, and misrepresentation.